Next, I want to ask if anyone was exposed to any reports, discussions, or anything about the case outside of the courtroom since you left yesterday and your return today, by show of hands. Thank you. Let the record reflect that there are no hands. And now I'll ask the state if you're ready to proceed.
Yes, sir. Your Honor, we request the court publish the stipulations entered by between the state of Florida and the defense.
All right. Thank you, Mr. Pruner. Ladies and gentlemen, I have a couple of stipulations that the parties have entered into. And I first have an instruction that you've heard me read to you before, but I will read it again before I read the stipulations. When parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are: I'm going to start first with stipulation regarding fingerprints, and it reads, it is hereby stipulated by and between the state of Florida and the defendant Michael Keatley that Florida law enforcement fingerprint examiner Keatley Adams examined the 10 .45 caliber spent shell casings from the Ocean Mist Court shooting scene and did not find any fingerprints suitable for comparison on any of the casings. And then it reads, we hereby certify that the foregoing stipulation is made in good faith and for the reasons herein alleged, dated this 18th day of February 2020, and then it is signed by the defendant Michael Keatley, Leanne Gowdy for the defendant, and Jay Pruner, Assistant State Attorney. The next stipulation that I have is titled Stipulation to DNA Results, and it reads, the state of Florida and the defendant Michael Keatley hereby stipulate or agree that the following facts are true and correct. DNA testing was conducted by Florida Department of Law Enforcement analyst Beth Ordeman on several items of evidence with the following results. Number 1, DNA identified on 2 spent .45 caliber Winchester casings collected from the homicide scene matched the DNA profile of Ramon Galan. Number 2, DNA identified on 1 spent .45 caliber S&B casing collected from the homicide scene matched the DNA profile of Juan Guitron. Number 3, DNA identified on 2 spent .45 caliber Winchester casings collected from the homicide scene matched the DNA profile of Gonzalo Guevara. And ladies and gentlemen, you will have these back with you. They will go back into the jury room with you, these stipulations. Number 4, a partial DNA profile obtained from 1 spent .45 caliber Winchester casing collected at the scene was insufficient to identify any person as to the source of the DNA. Sergio Guitron, Juan Guitron, Daniel Beltran, Gonzalo Guevara, Richard Cantu, and Michael Keatley are excluded as the source of this partial profile. Ramon Galan could not be excluded as the source of this partial DNA profile. Number 5, no DNA results could be obtained from 4 spent .45 caliber Winchester casings found at the scene of the homicide. Number 6, a partial DNA profile obtained from swabs taken from the steering wheel of the Chevrolet van driven by Michael Keatley on November 27, 2010 matched Mr. Keatley's DNA profile. Number 7, the Chevrolet van's driver's side floor mat, driver's side front seat, bottom and passenger side front seat adjustment lever, and a green towel collected from the van failed to give chemical indications for the presence of blood. And then it reads, we hereby certify that the foregoing stipulation is made in good faith and for the reasons herein alleged, dated this 18th day of February 2020. It is then signed by Michael Keatley, the defendant, Leanne Gowdy, attorney for defendant, and Jay Pruner, assistant state attorney. Those are all of the stipulations at this time. State ready to proceed?
Yes, sir. State of Florida rests, Your Honor.
All right, ladies and gentlemen of the jury, the state of Florida having rested their case, there's a number of things that I have to discuss with the attorneys before we proceed to the next phase, which is the defense case. So we are going to take a break. I am going to instruct you not to discuss the case amongst yourselves or with anyone else, not to do any research related to the case, and please avoid any reports of the case outside of the courtroom. All rise for the jury. has exited, everyone may be seated. Let me give my smarter half, my staff attorney, an opportunity to come down. I suspect we're going to hear legal arguments, and I can't do those without my staff attorney. I mean, I guess I could, but I like to discuss them. You can't have my staff attorney. Nobody can. Thank you. All right, state having rested, what says the defense?
Your Honor, at this time, the defense would move for a judgment of acquittal based on the presentation of the evidence thus far on this case. As the court is well aware, the indictment charges 2 counts of first-degree murder and 4 counts of attempted first-degree murder. As the court is also aware, each one of those charges requires the defendant to prove that Mr. Keatley is the one that committed these crimes. At this point in time, based on all the evidence that is presented, I would submit to the court that the eyewitness identification thus presented gives rise to its unreliability. First of all, beginning one by one, we have Jose Rodriguez, whose identification is suspect, to say the least. First, when he was presented the photo array by, I want to believe it's Detective Pramberger, on November 25th, 14 hours after the shootings, he could not pick out Michael Keatley out of that photo array. Beyond that, what we know is Jose Rodriguez is the only person who was on that porch that escaped uninjured. And Jose Rodriguez, we also know by his own admission, purchased from Mr. Keatley when he was operating the purple ice cream truck 8 to 10 times himself, and was present on numerous occasions when his children and his other family members purchased from that truck. He also testified that he had seen Mr. Keatley's picture on flyers that were going out after Mr. Keatley was shot. Despite all of that, he never, not once, says that the shooter looked familiar, that the shooter was the ice cream man. When he's interviewed by the first responding deputies that respond, one of them being Deputy Armstrong and the other one being Detective Woods. In addition to that, when he gives his statement to law enforcement at the D4 to Detectives Lugo and Schramm, which is recorded, he never once says to them that he recognized this person. In fact, says the person's a total stranger to him. It isn't until after he fails to identify Mr. Keatley out of the photo pack that's shown to him at 4 p.m. on the very day of the shootings that he starts hearing the rumor circulating that the ice cream truck guy who was shot in Old Sun City is the one that committed this crime. The following day, he's presented with the one photograph, which is depicted in Defense Exhibit Exhibit 13. He is shown that one photograph by his friend Juan Hernandez, and of course immediately goes, yes, that's the guy that committed the crime. Calls Detective Lugo, and Detective Lugo comes out and interviews him and confirms what not only Jose Rodriguez testified on the stand, but what I'm telling you occurred today. That identification did not meet the criteria for law enforcement to arrest Michael Keatley. He had concerns, Detective Lugo did, about that identification because of the influence of the rumors that had gotten to Jose Rodriguez, as well as the single photograph that was shown to him by Juan Hernandez. After that, what do we have? What we have is Gonzalo Guevara. And what we also know from Gonzalo Guevara, as we do from the surviving witnesses that testified. And so the surviving witnesses that testified, were able to testify, were Ramon Galan, Daniel Beltran, Jose Rodriguez, and Gonzalo Guevara. Because Richard Cantu was so injured that he does not remember anything from that night. Ramon Galan, Daniel Beltran, Gonzalo Guevara, and Jose Rodriguez describe an event that happened extremely quickly, that it doesn't take even them to tell us was a harrowing experience for them. It's frightening, confusing. It happened very, very, very quickly, and each one of them individually described their ability to view the perpetrator of these events only briefly. Not one of them testified that they recognized the shooter from anywhere. Not one of them told the first responding officers or the officers that spoke to them within minutes and hours of this event that they recognized the shooter from anywhere. Gonzalo Guevara, although he testified that he had never personally bought from the purple ice cream truck, had been on the porch at 604 Ocean Mist on many occasions, looking at Jose Rodriguez and family members from the Lucas family who lived at that address, purchasing from the purple ice cream truck, was aware that it was a single white male that drove that truck, and yet did not identify that person as being somebody recognizable to him or somehow linked in any way as being the shooter. And so what happens with Gonzalo Guevara? When we get to November 30th, Detective Lugo, in blatant violation of standard operating procedures that mandate, because the words shall are, means you have to do something, mandate what he's required to do, fails to follow that standard operating procedure, and instead takes it upon himself to be the one that is administering this lineup procedure. He had did it previously with Daniel Beltran. And he comes in and he goes to St. Joe's. He's only got one witness left to give him a acceptable identification, and that's Gonzalo Guevara. Why do we know that? Ramon Galan can't ID the shooter. Daniel Beltran does not ID the shooter. Jose Rodriguez does not ID the shooter until he's filled with information regarding that the shooter is the ice cream truck man and shown a single photo by his friend. And so when he gets over to the hospital on the 30th, this is his last chance for an identification. He doesn't show it at that time to Gonzalo Guevara because the nurse advises him, hey, not a good idea. He's been hallucinating and confused, or whatever the testimony was in that regard. What ends up happening is he comes back the next day, once again, in blatant violation of the SOPs. And what's interesting is the first time they go to show a photo pack on the 25th to Jose Rodriguez, they follow the SOPs. They have a person go out there to administer that sequential photo lineup who does not know who the suspect is. And once he fails to identify anybody, then afterwards it is Detective Lugo that's going out and administering these photo lineups to the various witnesses. And so what happens is when he goes on December 1st, he fails to turn on his recorder inexplicably when he gets there. He gets there at about 2:56 according to his own testimony. He ends up signing the instruction form, which is in evidence, at 3:37. So for approximately 41 minutes, he's conducting this photo array with Gonzalo Guevara. And he fails to record what happens during that photo array. We have the entire issue with that there's a 4 written on the photograph. We have the entire issue with that a 4 is initially written on the instruction form and later is changed by Detective Lugo to a 3. Mr. Keatley was in position number 3. So what we also know is that from Jose Rodriguez is that this text message that was going all around was also going around with the individuals that were in the waiting room. And that Gilma Guevara had been shown this text, who is Gonzalo Guevara's sister. And what we also know, after we talked with Detective Lugo yesterday, is that when he goes in on November 30th, it isn't just Gonzalo that's in the medical, in the room on his bed. His sister is also there. And what Detective Lugo says to him is, hey, not going to show you the photographs today. I want to make sure everything's okay when I show them to you. And that I'll be back every day. And remember my name and remember Detective Schramm's shirt. And Gilma Guevara is in that room when that's occurring. So everybody knows we've got a photo array that's going to be shown. And like Gonzalo Guevara testified, he anticipated that the suspect was going to be in that photo array. Based on the circumstances of the event, the circumstances of the ID, the circumstances surrounding the manner in which the photos were presented in violation of the standard operating procedures, which, as you know, today would create a presumption of suggestibility under the law. In 2010, that was not the law. But today, that is the law. And so all of those things would lead one to not consider those identifications neither out of court nor in court reliable. And because of that, those are the basic reasons why we had filed our motion to suppress, and frankly, it didn't get any better at trial. And so based on that, Your Honor, when you apply a beyond a reasonable doubt standard, I believe that if you exclude the the identifications of Mr. Keatley, both from Jose Rodriguez and Gonzalo Guevara, you're left with a purely circumstantial case. And the purely circumstantial case does not defeat every hypothesis of innocence. And therefore, these matters or these charges have not been proved at this point to a manner, even in the light most favorable to the state, to a manner that these charges should go to the jury. If I could have a minute to talk to Mr. Gonzalez and see if I missed anything. In addition to that, Judge, I would renew all the motions for mistrial and all the previous motions we made and objections we made during trial at this time, as well as during jury selection.
Absolutely. Same rulings at this time, but I'll give you a moment to talk to Mr.
Sure.
Gonzalez.
I don't have anything else to say, Your Honor.
But let me just have a question. What you argued that it hasn't, if it's circumstantial, if I don't consider the identification, that it doesn't overcome all hypotheses of innocence.
That's correct.
But you haven't suggested a single hypothesis of innocence.
Sure. So what you have in evidence thus far is that this neighborhood is a neighborhood that has gang activity in it. You have that these, at least 3 of the individuals that were on the porch, one of them ultimately isn't on the porch at the time of the shootings, go and buy cocaine from somebody. For whatever reason, law enforcement didn't follow that up. In addition to that, you have somebody that's coming up and talking about Creeper, who, for some reason, nobody wants to tell this individual, who we're to assume at that time they really did believe was a police officer, hey, by the way, Creeper's over there, because they didn't want to get Creeper in trouble. That's my memory of the testimony. You also have photographs of Omar Bailon, aka Creep, not Creeper, who did live at, I want to say the address is 507 Ocean Mist Court, who you have photograph after photograph after photograph of him throwing gang signs down. He's got Ocean Miss Gangsters tattooed on his body. He's been affiliated with the West Side Gang. And so you have that circumstance. You have Detective Lugo pursuing the route of checking out Mr. Balon's girlfriend's baby's father. I think I've got that right. Who's incarcerated at the time of the shooting, to try to pursue that angle to see whether or not that individual, through jail calls or anything, they could somehow link. But what ends up happening is that because he ultimately goes back and focuses on Mr. Keatley, that's where all leads ultimately die. Once we get focused as law enforcement on Mr. Keatley, that's the route that they pursue pretty much exclusively. The rest of the investigation that occurs past the afternoon of November 25th, 2010, is all about getting more information to suggest that it's Mr. Keatley that committed this crime, as opposed to anybody else. The other thing that you know is this. You know that even the state's witnesses describe the lack of Mr. Keatley being able to use his right hand. I mean, Terry Bowes described it. Reluctantly, the two disgruntled girlfriends described it. I want to say Norma Towers at one point, even though she was acting like he suffered no injuries, held her hands up and showed them to the court and the jury with both hands pointed down. She called it limpy or something like that, limpy wristed. He had a limp. None of these surviving victims that were, remember what happened that night, described not only that the shooter is familiar to them, but they don't describe the person having any difficulty whatsoever handling the firearm or in any unusual appearance of his gait. So what we know is that the person that comes up and commits this crime fits basically a general description. He's 6'2", anywhere from 250 to 300 pounds, depending on which victim you're talking to. We know from Detective Lugo's testimony yesterday that Mr. Keatley, at the time that he's arrested, weighs 212 pounds, and Detective Lugo testified that's consistent with what he saw. You have a situation where they're describing the individual handling a pump-action shotgun, and both Daniel Beltran and Jose Rodriguez, Gonzalo Guevara, Daniel Beltran, and Jose Rodriguez all talk about a pump-action shotgun. In fact, Daniel Beltran called it a 12 gauge. Daniel Beltran and Jose Rodriguez say they could hear and see the person racking the firearm after each shot. So because of the wildly, in many aspects, if we were to go by description by description, each description, you're going to see differences in every single one of the victims, which frankly is understandable. This was a quick event, startling event, scary event. They had seconds to view this person. People were getting shot. It was a horrible, it's totally understandable that they didn't really get a good look at this person. They were weapon focused. That's why they can describe the weapon. That is normal behavior for eyewitnesses that are experiencing a crime being committed, and especially a violent crime. And so that's what you have here. Based on that evidence, I believe that there's reasonable hypothesis of innocence that somebody else committed this crime. I'm not here, listen, we don't have a badge. I've sometimes, in the 21 years I've been a defense attorney, have wanted to have one, because maybe I could get people to talk to me without serving them with a subpoena. But I can't do that. I don't have anything to prove here, as the court is well aware. It's the state that's got to prove it. And at the end of the day, the state, based on their own evidence, can't get past his injuries. The only people that describe Mr. Keatley firing a firearm are Wesley Smith, who in his first interview with Detective Lugo claims he thought it was weird that Mr. Keatley gave him the gun and told him to fire it. He thought it was weird that he didn't try to fire it to the end, that he had all these difficulties handling the firearm. He describes all of that to Detective Lugo on December 7th, if we're to believe that Mr. Keatley even fired a gun when he's out there shooting with Wesley Smith. David Beckwith claims that Mr. Keatley had fired the gun with him at some other junk car at some other period of time out on the Keatley property. He also said initially on direct that when he held the gun to Mr. Keatley's head, that he took the gun and threw it on the ground. And then on cross, he was backtracking that and claimed he threw a loaded .45 at Mr. Keatley after he had just held it to his head. And those are the only two people, a 4-time convicted felon who demanded immunity when to speak to law enforcement, and his good buddy Wesley Smith, who claims that this man was having all these difficulties handling a handgun, let alone, nobody describes a pump action shotgun or anything remotely that Mr. Keatley handling anything that remotely looks like a pump action shotgun. So beyond that, the only other person that you have is Norma Jean Towers. And Norma Jean Towers sat up here on direct, was, rolling her eyes and making faces when she was talking about what a slob Mr. Keatley's car was and what a slob this was. But meanwhile was dying to reconcile with him, and he wouldn't return only but 2 of her many text messages. She also, when she gets interviewed by Detective Lugo, which within days of Mr. Keatley's arrest, never once mentions that she saw Mr. Keatley fired a gun. She had the nerve to stand up here and testify under oath that she didn't really know what Detective Lugo was investigating. We all know that that really belies logic, reason, and the truth, and we heard it from Detective Lugo yesterday. When he met with her, he made it clear what he was investigating and why he was talking to her. And yet she never says, oh, I saw him fire a gun. She never says, oh, I saw a shirt at his house when she's speaking to Detective Lugo. In all that searching that they did with metal detectors on, let's just go on the 28th, where they supposedly were only using the metal detectors within the fenced-in area surrounding the actual Keatley residence. Guess what they didn't find? They didn't find any shell casings consistent with the gun she claims he fired. So, to me, you sit here now analyzing the evidence that's been presented to you, and you've got to make that determination whether you believe that the state, assuming that you agree that beyond a reasonable doubt the eyewitness identifications are unreliable, whether their circumstantial evidence excludes every reasonable hypothesis of innocence. Not whether I proved that somebody else did it, because I don't have that badge, and I don't have the authority of a state investigative subpoena. And the burden isn't on Mr. Keatley. Thank you, Your Honor.
You're welcome. Mr. Pruner?
Thank you, Your Honor. As the court is aware, at this juncture, the legal standard is that the court must view the evidence in a light most favorable to the state, and that it is not appropriate to make credibility determinations or to resolve any the probative value of any conflicting testimony. With that being said, what that translates to, I suggest, Your Honor, in this context is we have 2 in-court identifications, which in and of itself, they're sufficient to get beyond the JOA. But that's not all we have. Of course, there's ballistics evidence, firearms evidence, which links this defendant to the scene. Even though the state is not required to prove motive, there is overwhelming evidence of motive, that he was searching for creeper, a Mexican male that he believed was accountable or responsible for injuring him, that he denied 7 times in the interviews ever uttering the word creep or creeper, that he knew anybody like that. He also had access to and was known to have driven, by his own admission, although at a different time, a dark-colored van that night, which is consistent with the description of the surviving victims. There's much more direct and circumstantial evidence, but those facts, in and of themselves, as viewed as the light most favorable of the state, is sufficient for this court to deny the motion for judgment of acquittal.
Thank you, Mr. Printer. Is there anything else from the defense, Ms. Gowdy?
No, Your Honor.
All right, we'll take a brief break, and I'll return with my decision. 5 minutes. Absolutely, yes, absolutely. We can't proceed without her. Thank you. Miss Caddy, would you like to wait for Mr. Gonzalez?
No.
All right. All right. Having considered the arguments from the attorneys, the evidence that's been presented, and at this stage, since the state is entitled to all inferences in their favor, I am going to deny the motion at this time, Ms. Gowdy.
Okay, Your Honor.
So, do you have witnesses
Yes, I
ready?
do.
So we're ready. If we bring
We're
in the
ready.
jury, call your first witness?
Yes.
Excellent. State ready?
Yes, sir.
All right. Let's get the jury. Who's the first witness, Ms. Gowdy?
I'm gonna call Jessica Hadley.
Hadley?
Hadley.
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 Thank you.
Yeah, Jessica.
We are.
All right, jury entering.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. At this time, we are now going to turn to the defense case, and I'm going to ask the defense to please call their first witness.
Jessica Hadley.
Jessica Hadley. Miss Hadley, good morning and welcome. If you'll come forward to be sworn, watch your step. If you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. If you'll follow the bailiff around to the ramp, and also, again, please watch your step. There's cords that are taped down. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone in front of you does adjust up and down, and it slides forward if necessary.
Good morning, ma'am. Could you state your name and spell your last name for us?
Jessica Hadley, Hadley.
And Miss Hadley, do you live here in Hillsborough County?
Yes,
How long have you lived in Hillsborough County?
all my life.
Where'd you grow up?
In Wyomama.
Are you familiar with where your parents live?
Yes.
What's their address?
4949 Bonita Drive.
Is that where you grew up?
Yes.
Do you have any siblings?
Yes, older sister Lisa, my older brother Michael, and then I had a younger brother Charles.
Do you see your brother Michael here?
Yes.
Is he seated over here at this table over
Yes.
to I think that's my left. My left?
Yes.
Are you married?
Yes, I am.
And where do you currently live? Not the address, but the section of town where you live.
In Suffner,
In Sefner. And how long have you lived in Sefner?
since 2010.
Back in January of 2010, did you become aware that your brother had been shot while operating his ice cream truck?
Yes,
And did you visit him while he was in the hospital?
yes, I did.
And when you saw him in the hospital, what did you observe as far as injuries?
His right arm was bandaged up. His left arm was bandaged. His hand bandaged.
That's what
Yeah,
you observed?
yes.
Did you see your brother Michael after he got out of the hospital?
Yes.
And I'm going to talk about the time period between the time he gets out of the hospital and Thanksgiving Day, November 25th, 2010. During that time period, so after he gets out of the hospital up to Thanksgiving Day, how many times would you say you saw your brother Michael?
3 or 4 times.
And where did you see him?
Mostly at my parents' house.
Before he got shot while operating his ice cream truck, did he live with your parents?
No, not before.
After he came out of the hospital, did he live with your parents?
Yes.
And how do you know that?
They turned the dining room into a bedroom. They put a bed, a hospital-type bed, inside there for him.
And did you see that?
Yes.
The 3 or 4 times before Thanksgiving that you saw your brother, could you describe what injuries you saw in him during those periods of time?
He had a brace on his right hand. A lot of times he was wearing it with the sling on there. He wasn't really able to use his right hand. He was mostly using his left hand.
Do you recall whether or not you ever observed him needing help with anything?
Yes, my mom, when we were eating, she cut up his food so that he could eat it with his left hand.
Did you ever see him need any help getting dressed?
Yes, one time there at the house, my mom was helping him put on a button-up shirt and put the sling on for him.
Back in 2010, were you working a full-time job?
Yes,
And do you have children?
yes, I do.
How often would you say you would be able to go over to your mom's house and visit during that time?
We go every other month or so.
Now, did you observe whether or not your brother walked with a limp?
Yes, he did have a limp.
Did there come a time during the time period before Thanksgiving where an alternator needed to be changed in one of the family cars?
Yes, my mom's car needed the alternator changed, and
And could your brother Michael change that alternator?
no, he said he couldn't, and so he asked my husband to help him. So he told my husband how to do it.
And before he got shot, would that have been, based on your growing up with your brother, would that changing of the alternator been something he could do on his own?
Yes, he liked to work on cars. He worked on cars since high school.
So now let's get to Thanksgiving Day, 2010. Did you host Thanksgiving at your house?
Yes,
And that was your house in Sefner?
yes.
Who came over for Thanksgiving?
My mother-in-law, my mom and dad, and my brother Michael.
And in your family, your direct family, who was present?
My mom, dad, and my brother Michael.
No, I'm talking about
My son and my daughter and my husband.
Okay.
Sorry.
So, what time were you serving Thanksgiving on that particular day?
We were trying to eat early, around 12:30, because my mother-in-law had to go to work that day.
And were you present when your mom showed up with your dad and Michael?
Yes,
Did they all come in the same vehicle?
yes,
Did they bring any food?
yes.
Okay, you smile. Why do you smile?
My mom likes to cook and make things, so she brought her usual things. She made her homemade macaroni and cheese. She brought her homemade potato salad, deviled eggs, baked beans, corn on the cob, her homemade apple pie, pumpkin pie, homemade cheesecake.
Too much food.
Yes.
Was this something that growing up and into your age now, your mom always did and does?
Yes, she always likes to make a lot of food.
And did Michael, your brother, carry anything from, well, what car did they come in? Did your parents come in?
My dad's truck.
Okay. What, did Michael, your brother, carry any of that food
No,
into the house?
no, he did not.
And did you in fact eat at 12 or 12:30 that day?
Around that time, yes.
Did your brother have the same difficulties that you've described to us today with eating on Thanksgiving Day, November 25th, 2010?
Yes.
How would you describe how he was eating his food that day?
My mom was cutting up the meats, and so then he just kind of was able to kind of scoop it up onto the fork into his mouth.
With what arm and
His
what hand?
his left hand and arm.
Was he walking with a limp on that day?
Yes.
And was that the same kinds of injuries that you had seen with him since he came out of the hospital?
Yes.
If I could have a second, Your Honor.
Absolutely.
Did you notice anything different about your brother that day as far as his demeanor or the way he was acting or anything like that?
No.
Did he appear like he did to you any other time that you would see him?
Yes.
I don't have any other questions.
All right, cross-examination. Thank you. Good morning, ma'am. You don't have any personal knowledge of where Michael Keatley, the defendant, was at approximately 2:30 on that morning of Thanksgiving, November 25th of 2010, do you?
No.
And at that time, your parents had a blue van that you had seen this defendant drive on occasion, even after he had been shot. Isn't that correct?
Yes.
You were not aware of any plan that your brother, the defendant, or your parents had as of Thanksgiving Day to have that van painted?
Not that I'm aware of, no.
And in fact, your brother was a very good mechanic
Yes.
from when he was in high school. He chose that as his profession or career, isn't that correct?
Yes.
He became an airline mechanic.
Yes.
He had to graduate from National Aviation Academy.
Yes.
And he held a number of jobs in the aviation industry with Delta Airlines and Grumman and other places, isn't that
Yes.
correct?
Yes. That was-
Did he, meaning the defendant, ever share with you that he was asking people along his ice cream route for information to help him determine who had shot him?
Not to me, no.
Did he ever share with you that he was asking specifically for the whereabouts or the identity of someone named Creep or Creeper?
No.
The brace that you described on that Mr. Keatley wore on his right hand covered and came all the way down to his knuckles, did it not?
I believe so. This came out, at least, yeah.
And it wrapped around his wrist?
Yes.
And was visible all the way to the back of his wrist, correct?
I would say so.
Let me show you what's in evidence in State's Exhibit number 98. You recognize the individual in the police canine shirt as your brother, Michael Keatley?
Yes.
And doesn't that fairly inaccurately depict his build on that Thanksgiving day of, this wasn't taken on Thanksgiving Day, I'm not suggesting it was, but is that consistent with his build and appearance at the time you saw him on Thanksgiving Day, November 25th of 2010?
I would say most likely. I can't, yes, it looks like him.
Tell us if there's anything drastically different, please tell us.
No. No, yeah, it looks like him.
Okay. And do you see any brace, although you can't see really much of his right hand, but do you see any indication of a brace on that right hand?
No, I don't.
And with that right hand in that picture, he is grasping or caressing or holding, whatever the correct term would be, a woman's right shoulder. Is that correct?
Yes, that's what it looks like.
The hand isn't gnarled up or in a disformed position as shown in this photograph. Is that correct?
Correct.
Have more, please.
Yeah.
Do you recall whether or not your brother, the defendant, had voiced frustration or being upset with the sheriff's office investigation into his shooting incident where he had been robbed and shot?
Not to me, no.
Nothing from that.
Redirect.
You weren't at this party, were you?
No, I
That's
was not.
depicted here on State's Exhibit 98, correct?
Correct, I was not.
Okay. And were you at, and when your brother came over for Thanksgiving, did he have a beard? Look at the picture. Did he have the beard when he came over on Thanksgiving?
I don't believe so.
Okay. Was your brother normally clean shaven?
More often, he was clean shaven.
When you would see him and he had a brace on his hand, he didn't have a brace on his hand every time you saw him, the whole time you saw him, did he?
No, I mean, sometimes when he was laying, because he laid down and took naps and things like that, and he had it off, so.
Okay. And you don't know how the prosecutor characterized him as grasping the woman that we see in this picture's shoulder. Does he look like he's grabbing anybody's shoulder there to you?
Not really, just more his hand being there.
It just looks like his hand is laying there, correct?
Yes.
I don't have any other questions.
May this witness be excused by the defense?
One more. How long was he at your house on November 25th?
Until late afternoon, probably 5 or so.
At any time that day, did you see him grab anything with his right hand?
Not that I recall.
I don't have any other questions.
May she be excused by the defense
Yes.
and by the state?
Yes, sir.
Thank you, ma'am. You may step down. You may be excused as a witness at this time. I'll ask the defense to call your next witness.
Tom Dirks, Detective Tom Dirks.
Detective Dirks. Detective Dirks, welcome. Good morning. If you'll come forward to be sworn wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, Detective. You'll follow the bailiff around to the ramp that leads up to the witness chair. Please watch your step. There's some cords that are taped down. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone does adjust up and down, and it moves forward if necessary.
Perfect. Thank you.
You let me know when you're ready, and then I'll allow the attorneys an opportunity to ask you some questions.
Okay, I'm ready, sir.
All right, Ms. Gotti, you may proceed.
Good morning, sir.
Good morning.
Could you please state your name for the record and tell us who you work for?
Yes, my name is Tom Dirks, D-I-R-K-S, and I work for the Hillsborough County Sheriff's Office.
And how long have you worked for them?
Just over 25 years.
Back in November, specifically November 25th of 2010, what division within the sheriff's office were you working for?
At that time, I was employed in the Criminal Investigations Division.
And were you a homicide detective then?
Yes, it was.
Were you asked at any point to assist in the investigation of shootings that happened that resulted in 2 individuals being killed and 4 injured over at 604 Ocean Mist in Ruskin?
Yes, ma'am.
And did you get asked to interview some potential victims/witnesses?
Yes, ma'am, I did.
Who did you get asked to interview?
Can I refer to my report? That's okay?
Absolutely.
I was told that there were 5 individuals sent to numerous hospitals, 3 of which went to Tampa General Hospital, 2 of which went to St. Joseph's Hospital. At the time that I was contacted by my corporal, we were not sure who was going to be available for any statements, but I was asked to see what the prognosis was at the time, and to see if I could get any kind of statements from any of those individuals.
So did you go to the hospitals to see if you could do that?
Yes, I did.
And did you travel to any particular hospital first?
Yes, I went to Tampa General Hospital first.
When you were at Tampa General Hospital, were you able to interview one of the victims/witnesses?
Yes.
And who were you able to interview while you were there?
That individual was identified as a Daniel Beltran, date of birth of March 7th, 1986.
After you interviewed Mr. Beltran, well, let me ask you this. Was Mr. Beltran able to give you a description of the individual that shot them?
A generalized description, yes.
Okay. And did Mr. Beltran indicate to you that this individual had asked for a particular person when he walked up to the porch?
Yes.
May we approach?
Did Mr. Beltran indicate to you what name the shooter had asked for?
Yes.
And what was that name?
That name was described as creepers.
With an S?
That's correct.
Did you put that in quotes?
Yes, ma'am, I did.
And the interview that you conducted with Mr. Beltran at Tampa General Hospital, if you need to refer to your report, I'm sure with the court's permission you can. Do you remember what time that took place on November 25th,
Yes.
2010?
Yes, I believe it was approximately 04:55 hours.
Is that 4:55 in the morning?
Yes, ma'am.
Okay. After you interviewed Mr. Beltran, did you go to any other hospital?
Yes.
What other hospital did you go to?
St. Joseph's Hospital.
And were you able to speak to any victim / witness at St. Joseph's Hospital?
Yes.
Who were you able to speak to?
An individual that was identified as Gonzalo Guevara, Guevara.
And did Mr. Guevara also tell you that the shooter that had come up on the porch had asked for an individual by name?
Yes.
And what was that name that he gave you?
He also gave the name of creepers.
Okay, and did you put that in quote as well?
Yes, ma'am, I did.
Did you ask Mr. Guevara to describe this individual in reference to you?
In comparison, yes.
And were you standing at the time that you asked him to make that comparison?
Yes.
And did Mr. Guevara appear lucid and while in pain? Did he appear lucid and like he was able to answer your questions and understand your questions?
Yes, ma'am.
And how tall? How tall were you in 2010?
Approximately 6'5", between 6'5" to 6'7".
And I'm sorry, I've got to ask you
Ask away.
the question I'm about to ask you. How much did you weigh?
At the time, I know I was over 300 pounds, probably about 350 pounds.
Okay. And was your hair similar in style to what it is today?
Yes.
The color of your hair back in 2010, was it different than it is today?
A little less gray, but it was brown primarily.
Did Mr. Guevara describe the individual's hair and style and color reference your hairstyle and color?
I believe so, yes.
And what did he tell you about the shooter's hair in reference to your hairstyle and color?
Stated that his hair was brownish and or orangish and had short hair.
Short hair.
That's correct.
And did you ask for any further clarification reference your hairstyle as to what he was meaning by short hair?
I believe he just said it was similar. I don't remember if it was shorter or longer, but just similar to mine at the time of the questioning.
Okay, which is similar to what we're seeing today.
A little bit longer, but yes.
Okay. And did he describe this individual as far as height compared to you?
Yes, he told me at first that he was approximately 6'1" to 6'2" in height.
And did he ever change that in any way?
When I asked after he gave a generalized description as far as height and weight, I did a comparison to myself, just because people's perception of heavy set, not heavy set, their perception may be different than mine. So I did compare him to myself, yes.
And what did he say reference to you as far as the shooter's height?
Well, he did say that he was shorter than I was at the time, but he also said that he wasn't as wide as I was. He was somewhat heavy set, and that may have had like a pop belly or a little bit more of a belly than I had at the time of the interview.
What was your impression of weight of the shooter based on what he was telling you, reference you, your size, and what Mr. Guevara was describing?
Objection.
Legal basis?
Impression, opinion.
I'm sorry?
Impression means opinion. Speculation.
Opposite statement is speculation.
If I could have 1 second, Your Honor?
Yes.
When he described the firearm, what did he describe?
I believe he said it was a shotgun.
Okay, and did he ever tell you that it was 10 inches?
Not that I can recall.
Are you familiar with a 10-inch shotgun?
I'm familiar with shotguns. I don't know the exact measurement of the shotguns that I've come into contact with, but yes.
Okay, have you ever seen a 10-inch shotgun?
Again, I'm not usually measuring barrels of shotguns when I interact with them, so I can't accurately answer that.
Okay, well, describe to me what length you typically have seen a shotgun.
From stock to end of barrel,
What would you say that is? You're holding your hands up.
approximately 14 inches.
The way you just held your hand up was 14 inches?
Yes, ma'am.
Okay. Is there that yardstick? Does the court have that yardstick still behind the bench? Hold your hands up again the way you have. Let me do it this way so you can read what it says. Where are we?
We're at double that, 28.
I don't have any other questions.
Cross. May we approach?
instruction at this time. The evidence that a witness may have made a prior statement that is inconsistent with his or her testimony in court should be considered only for the purpose of weighing the credibility of the witness's testimony and should not be considered as evidence or proof of the truth of the prior statement or for any other purpose. You may proceed with cross-examination.
Thank you. When you spoke with Gonzalo Rivera, it was obvious to you that he was in considerable pain,
That's correct, yes.
and he was being treated by medical personnel throughout and intermittently as you were talking to him. Is that correct?
Yes, sir, that's correct.
Not the ideal setting for a detailed investigative interview, would you agree?
Yes,
But your purpose there was to obtain whatever information you could as soon as possible to facilitate the investigation as quickly as possible. Is that correct?
that's correct.
In part because, as you alluded to in your direct examination, you really didn't know the prognosis for any one of these 5 people that went to the hospital. You didn't know if you got a statement if they die later or not.
That's correct. We had 3 individuals that I couldn't talk to at the time. 2 were in surgery. 1 had a significant head injury, and these other 2 individuals were the only ones there available for a statement.
And Mr. Rivera wasn't standing up face to face with you. He was flat on his back as you interviewed him.
That's correct, either flat on his back or on his side, but yes, he was lying in a lying position.
And that's not the position that he was in at the time he observed, he described having observed the shooter.
Objection.
Legal basis?
It's speculative on his part.
Well, only if the witness knows. I'll caution the witness not to speculate.
I'm not sure exactly what position he was in.
All right. Do you recall having been interrupted at times in your attempt to converse with him?
There were some interruptions, but I don't know exactly how long they lasted or how many.
Okay. However, he was able to give you a verbal description of 6'1" or 6'2" as being the height of the shooter.
That's correct.
He also described the shooter as having rosy cheeks.
That's
Is that
correct. Yes, sir.
Wearing chrome-colored eyeglasses, correct?
That's correct.
He also told you he had a black-colored bulletproof vest with sheriff printed on it.
Yes, that is correct.
Didn't he also tell you that the unknown person was somewhat heavy-set and had brownish or orangish short hair?
That's correct.
May I have a moment?
Yes.
Mr. Beltran to you described the shooter as a 6'2" white male, didn't he?
Objection. May we approach?
Sure.
further questions, thank you.
Any redirect?
No, Your Honor.
May this witness be excused by the defense
Yes, Your Honor.
and by the state?
Yes, sir.
Thank you, Detective. You may step down. You may be
Thank
excused as a witness at this time.
Yes, sir.
I'll ask the defense to call your next witness.
Jacqueline Burgess.
Jacqueline Burgess. Ms. Burgess, good morning and welcome. If you'll come forward to be sworn as a witness wherever you're comfortable, if you'll please face me and raise your right hand. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. If you'll follow the bailiff around to the ramp that leads up to the witness chair, please watch your step. There's some cords on the floor. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone does adjust.
Good morning, ma'am.
Good morning.
Could you please state your name and spell your last name for the record?
Jacqueline Faith Burgess.
Speed freaks devour speed. Yummy, yummy speed. Speed Freaks have gig service internet for just 74.
Yes.
And had you seen him since when he was shot earlier in that year?
No.
And so would this be the first time that you had seen him after he had been shot?
Yes, it was.
Did he appear to have any disabilities or any injuries to you when you saw him on Thanksgiving Day 2010?
Yes, he didn't have use of his right arm. He had a brace on his hand and I believe on his, maybe on his upper arm area as well. So he wasn't able to use his right arm. And when we sat down to dinner, he sat next to his mother, I believe, and she would help him, you know, cut up his food. So.
And could you see him, was he able to feed himself?
I believe he, yes, but he didn't, yes, he used his left hand to eat.
Did you notice anything about his demeanor on that day that was different any other time you had ever seen him since 2003 when you relocated to the Hillsborough County area?
No, not really. He
Okay.
was the same Michael that I'd met, you know, seen previously.
If I could have 1 second, Your Honor. I don't have any other questions. Thank you, ma'am.
Cross-examination?
Yes, thank you. Good morning, John.
Good
You
morning.
didn't see Mr. Keatley, the defendant, try to use his fingers on his right hands at all, did you?
No,
And you don't know whether he could or could not use his fingers in any fashion, do you?
I don't know if he could. All I know is he didn't.
He did. And you don't know what he could do with his fingers without that brace, do you?
No.
Thank you. Nothing further.
Any redirect?
No, Your Honor.
May this witness be excused by the defendant?
Yes.
And by the state?
Yes, sir.
Thank you, ma'am. You may step down. You may be excused as a witness at this time.
Thank you.
I'll ask the defense to please call your next witness.
Your Honor, could we have a minute?
Yes.
Can I see if I have a witness outside?
Absolutely. Ladies and gentlemen, we're going to go ahead and take our morning break. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid all reports of the case outside of the courtroom. All rise for the jury. It'll be approximately 15 to 20-minute break. So. Jury has exited. Everyone may be seated. All right, that should be enough time, and we'll pick up where we left off. Ms. Dowdy, anything from the state? All right, enjoy the break.
testing. So in this particular case, we did do the screen for alcohol. We did the screen for 12 different classes of drugs of abuse, and we did that on the cavity blood. And then we also did a comprehensive drug screen using gas chromatography, mass spectrometry, which is a state-of-the-art analytical instrument that can actually uniquely identify different drugs. And doing that screen on this particular case, we identified 3 different substances in this individual.
And what were those substances?
The first substance we identified was the presence of ethanol, which is what's included in beverage alcohol, say in like beer, wine, or liquor. We detected ethanol in the cavity blood at a concentration of 0.02 grams per deciliter. We also confirmed the presence of ethanol in the ocular fluid or eye fluid, and the concentration in the eye fluid was 0.02 grams per deciliter. In addition, we detected the presence of a cocaine metabolite called benzoylecgonine, and that was identified in both the cavity blood as well as the ocular fluid. And then the third substance we identified was tetrahydrocannabinol, or THC, which is the active ingredient of marijuana as well as a marijuana metabolite.
As far as the amount of ethanol, how does that relate to those of us that maybe don't understand what the numbers mean, but maybe understand to how it relates to, like, for instance, somebody's ability to drive? What the legal limit is of alcohol in your bloodstream for you to be able to drive a vehicle?
The legal limit for drunk driving is 0.08. So this is below that. It's 0.02,
Okay.
so it's about a quarter of the legal limit.
Obviously, this individual, Sergio Guitron, had come to the medical examiner's office deceased.
Yes,
Okay. And so the items that you are examining, the specimens you're examining, are specimens that are collected during autopsy.
correct.
Did you also, were you also involved in running the toxicological panel on an individual by the name of Juan Guitron?
Yes.
And tell us about that.
On Juan Guitron, we performed a more limited analysis. It looks in his particular case that we didn't have enough specimen to do the full comprehensive drug screen that I talked about with the previous case. So based on the amount of sample we had on him, we only did the screen looking for alcohol and volatile substances, as well as looking for 12 different classes of drugs of abuse. We didn't have enough volume to do the third tier, more comprehensive testing.
And as far as the alcohol concern, what was his, what did his blood level reflect?
His blood ethanol level was 0.02 grams per deciliter, and that was in the antemortem blood. That was the blood that came from the hospital. And then we also detected ethanol in the eye fluid at a concentration of 0.01 grams per deciliter.
And when we, obviously you just said that he had come from the hospital where he had passed prior to coming to the medical examiner's office, correct?
Correct.
And are there things that can take place when somebody gets taken to the hospital with injuries such as gunshot wounds that can dilute quantities of alcohol in that person's system?
Yes, they could potentially be giving that individual saline or IV fluids. They could also maybe giving blood transfusions, which are going to dilute that person's blood.
Now, I asked you to take a look at a record, and the record is located on page 1296 of 1315 of Gonzalo Guevara's medical records that are in evidence as defense exhibit number 15. And do you see there where the hospital, fortunately, you didn't have to run any panels on Mr. Guevara because he survived, correct?
Correct.
All right, and so do you see there where the document that I just showed you reflects a serum alcohol or ethanol content?
Yes.
And what does that reflect?
At St. Joe's Hospital, his serum ethanol concentration was 161 milligrams per deciliter.
And can you convert that to what the legal blood amount was?
Yes, essentially what a hospital is doing is they're not analyzing whole blood. What they actually do is centrifuge that blood and remove the blood cell components. So it actually concentrates the alcohol a little bit in the serum that they're testing. So typically when we're converting serum alcohol results to whole blood alcohol results, we reduce that number by 15%, which reflects the loss of the volume of the blood cells that they removed. So if we subtract 15% from a 161, we're going to come up with a 0.14 grams per deciliter whole blood equivalent.
Okay, and so what is that, a 0.14?
0.14, which is higher than the legal limit of 0.08.
As a toxicologist, do you know how alcohol affects a human being?
Yes.
And how does it affect a human being?
Alcohol is that.
Insufficient predicate outside the scope invading the jury's province.
Do you remember the question?
Yes.
Can you answer the question?
Ethanol is a central nervous system depressant, so it depresses various regions of your brain that control your behavior and motor skills.
And when you say that it suppresses the central nervous system,
Yes.
and it affects how it can control your behaviors and motor skills, what do you mean by that?
Well, it depends on the dose of alcohol that you take. Initially, when someone consumes 1 or 2 drinks, they tend to get a little bit euphoric. They feel good. They're kind of relaxed, everything like that. If they consume more alcohol, you're going to start to see more significant effects of the alcohol in that individual. You might start to see slurred speech, strange behavior, a little bit more outgoing behavior, that type of thing. And you can also see a gradual effect on their psychomotor skills. So their balance might be affected. Their ability to operate a motor vehicle can be affected at higher concentrations. And if the alcohol concentration gets even higher, you can start to see clinical symptoms of intoxication where the person can actually pass out, lapse into a coma, and alcohol can even cause death at high concentrations.
At a 0.14, is that at a level where the motor skills and, well, let me ask you this. What would you expect to see based on your experience and your education regarding toxicology at a 0.14?
It's going to depend on the person's individual tolerance to alcohol, whether it's a person who's never consumed alcohol at all or whether it's a seasoned person who drinks on a daily basis. But in general, at a 0.14 alcohol concentration, you're going to start to see some effects on that person's psychomotor skills as well as some of their behaviors.
Okay. And what about if, in addition to the alcohol, the person has cocaine in their system? What about, how does cocaine affect the human body?
Cocaine is actually a stimulant, not a depressant. So
And
it
so
has
what
the
is-
opposite effect.
And so what does it do?
Usually cocaine produces a really good sense of euphoria, well-being, a lot of energy, maybe hyper, talking too fast, really rapid movement. They get very excited, agitated with cocaine because it's a really strong stimulant.
And when they get combined, when cocaine gets combined with alcohol, what effect would that have?
You're going to get mixtures of effects on that individuals, anywhere from the the behavioral effects we talked about with alcohol, you can also start to see behavioral effects due to cocaine as well.
And what about marijuana? How does marijuana affect the human body?
Marijuana is a different class of drug altogether. It's more of a psychoactive type drug. It's not actually classified as a stimulant or a depressant.
And how does it interact with alcohol and cocaine?
It can act in combination synergistically with those two types of different drugs to produce greater effects because all three drugs are on board.
If I could have 1 second, Your Honor.
Absolutely. Cross-examination?
Thank you. As far as, good morning, Doctor.
Good morning.
As far as the toxicology on Gonzalo Rivera that was just provided to you,
Yes.
there weren't any, marijuana was not detected, is that correct?
I didn't see the drug screen results. I just looked at the first page. I didn't,
All right, well, I'm sorry, let me show you then 3 pages, and I'll let you pick out the appropriate information.
okay, there's the urine drug screen. So the urine drug screen on this individual was negative for cannabinoids or marijuana.
Now, blood alcohol content rises for a period of time after ingestion of alcohol, is that correct?
Correct.
For how long?
It can take up to an hour or two, depending on how fast the person's drinking, to actually get all the alcohol from their stomach into their bloodstream, producing an effect.
So the result that you have before you may not necessarily capture exactly the blood alcohol level at the time of an incident over an hour or two before.
Correct.
So stimulants are also used, such as Adderall, to enhance patients' focus and their concentration. Is that correct?
Yes.
Cocaine is a stimulant,
Yes.
correct? And it also can, under certain circumstances, act to enhance focus and concentration.
Yes.
So as to Juan Guitron, which was the one patient deceased, you indicated that the blood alcohol results were 0.02 grams per deciliter, or about 0.2. How's that work out again?
0.02 grams per deciliter.
Okay. And so that's about 1 drink of alcohol.
Correct.
And you were asked about certain medical measures that can dilute the blood alcohol toxicology results. And you indicated there were such medical procedures.
Yes.
Okay. But you don't know what, if any, medical procedures, if any of those diluting medical procedures were administered to Juan Guitron prior to his passing with the taking of these blood alcohol results.
Correct. I did not review those medical records.
Okay. And concerning Sergio Guitron,
Yes.
was also, there was an autopsy conducted at the medical examiner's office. What was the blood alcohol again, as converted to legal analysis?
0.02 grams per deciliter.
And that again is approximately 1 drink, is that correct?
Correct.
And if in fact Sergio Guitron was known to have died at the scene without medical intervention, would it be safe to conclude that was his blood alcohol at the time of that incident?
Yes.
And the cocaine reading, the level indicated to you that the cocaine use wasn't recent. Is that correct?
Correct. We didn't see any parent cocaine, and usually we can detect cocaine for maybe up to 4 or even 6 hours after a person uses cocaine. So we did not detect any parent cocaine in this individual, which indicates to me that he had probably used cocaine maybe even at up to 4 to 6 hours prior to his death, such that we just see the cocaine metabolite and not actually any parent cocaine.
And as far as the marijuana, can you tell from, was it quantifiable, the amount detected?
Yes, the THC concentration in the blood was 0.004 milligrams per liter, which is the same as 4 nanograms per mil. And then the metabolite, 11-carboxy, THC was 0.034 or 34 nanograms per mil.
And can you give us a feel for what those numbers mean as far as recency of ingestion or quantity of the amount ingested?
All I can estimate is that the person probably used marijuana within 6 hours prior to their death. It looks like a typical dose that we see in a recreational user.
Is it fair to say from that answer that that is indicative of use but not quantity?
It's indicative of use, but I can't in general testify to how great of an effect it would be having on him.
May I have a moment, please? Nothing further, thank you.
Redirect.
Ms. Pearson, do you know how many beers typically can produce a .14 in a person?
In a average male, 150 pounds, it would take about 7 drinks to produce a .14
And
blood alcohol.
And when somebody says that they were drinking from 10 o'clock until 2:20 in the morning, is the blood that's drawn at the hospital something where we get the .14? Do you know whether it could be that the person was actually increasing or going up, or whether they could be coming down?
I can't tell based on that amount of information. It depends what they were drinking, when they were drinking, how fast they were drinking. And it depends the rate at which they're drinking to determine whether or not his peak blood alcohol is .14. It could have been higher a couple hours early. I don't really know.
Okay, thank you. I don't have any other questions.
May this witness be excused by the defense?
Yes, Your Honor.
And by the state?
Yes.
Thank you, ma'am. You may step down. You may be excused as a witness at this time.
Thank you, Doctor.
I'll ask the defense to call your next witness.
James Kennedy?
James Kennedy. Mr. Kennedy, welcome and good almost afternoon. It's 3 more minutes of morning left. If I can have you step forward and raise your right hand to be sworn as a witness. Thank you. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you put your hand down. If you'll follow the bailiff around to the ramp that leads up to the witness chair, please watch your step. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone does adjust.
Good afternoon.
How you doing?
Could you please state your name for the record and spell your last name for us?
James Kennedy. Last name is Kennedy.
And Mr. Kennedy, do you live in Hillsborough County?
I do.
What do you do for a living?
I do home repairs, but I'm also a chemical engineer.
And did there come a time in November of 2010 that you sold a gun of yours on, or advertised it for sale on one of the gun trader
Correct.
sites?
Right, Florida Gun Trader.
Okay. And what was the gun that you sold?
Ruger 1022.
Describe that gun for us.
About 2 foot long, black barrel, medium wood stock, scope, semi-automatic, had a 5, 10, and a 20 round magazine, I believe, something like that.
Okay. What kind of, did that gun, how much would you say that gun weighs?
2 pounds? No, maybe 4 pounds. It's meant for a child,
It's a gun meant for,
like a child, a young adult.
okay.
It's like a first gun.
And I think you said it was about 2.5 feet, 2.5 feet long?
Approximately.
Does that gun, I know you said it was a 22, does that gun fire 45 caliber ammunition?
No,
What caliber ammunition did it fire?
just 22 long rifle.
Who did you sell that gun to?
Michael Keatley.
And do you remember when you sold it to him? What day in November you sold it to him?
Not the exact date, no.
Do you remember when you put the advertisement in Florida Gun Trader?
Just based on the listing, it was in November, early November, I think, something like that.
Okay. And where did the actual transaction take place?
301 in Gibston Drive in the parking lot of Winn-Dixie.
And when you got there, did you recognize Michael Keatley?
I did.
How did you recognize him?
Just facial features, just recognized his face from high school.
Where did you recognize him from?
Oh, from high school.
What high school had you gone to?
East Bay.
And were you friends with Michael Keatley in high school?
We were acquaintances, I guess. You know, we said hey to each other, chit-chat every once in a while, but
Did you socialize with him in any way after high school?
no.
When you saw him in that parking lot of the Winn-Dixie off of 301, is it then that you recognized him as somebody that you had known as an acquaintance in high school?
Yes.
You didn't know that before you met with him that day?
No, we just exchanged first names, and that was it.
Was it, did this sale take place during the day? Was it evening? Do you recall?
Probably late afternoon, early evening.
And so tell us what happened. You get there,
Got there, I think I got there first, and he pulled up in a white pickup, I believe. And he got out. When he got out, I recognized him. He recognized me. And we came up, shook hands, and talked for a few minutes. And I showed him the gun, and he bought it.
okay.
So,
Did he appear injured in any way to you?
yes,
Describe how he appeared to you.
he had limited use of, I would say, the right side of his body, because when I went to shake his hand, I had to switch hands, and I shake with my right, because he couldn't lift his right hand to shake mine.
And did you notice whether or not he walked with a limp?
He did.
Did you see him handle that firearm at all?
He grabbed it with his, I guess, his good hand, his good arm, and looked at it and just kind of glanced over it.
And did he buy it?
He did.
And how much did he pay for it?
I believe it was $150.
Did he pay in cash?
He did.
Is that something that's unusual?
Paying cash?
Yeah. Is
No.
it unusual if somebody's either selling a gun in the manner that you sold this one, where you advertised it on Florida Gun Trader, for you to receive cash as opposed to a credit card or a check?
No, it's more usual to receive cash. Because you don't know who you're dealing with.
How long would you say you interacted with Mr. Keatley on this day?
15 minutes, 10 minutes.
If I could, I'm going to show you a document and ask you whether this document can refresh your recollection as to when you had that Ruger rifle advertised on Florida Gun Trader.
Yeah, November 16th, 2010.
Do you recall whether you sold it after that?
It would have to be, yeah. That's usually that's the date when it was posted.
After you sold this firearm to Mr. Keatley in that parking lot, did you ever socialize with him? Did your relationship change? Did you start socializing with him or anything else like that?
No, that was it.
Now, that firearm, does it look like a pump-action rifle?
No,
Does it function like a pump-action rifle?
no.
How did that, you said it was a child or young adult rifle. How did that firearm function?
It had a slide catch. You pulled back to load the first round, and then you pull the trigger. It fires. You pull the trigger again. It fires. It's a semi-automatic, so you have to pull the trigger every time you want it to fire.
And did it have, I'm learning this terminology every time, but did it have like the butt of the gun? I call it the butt of the gun.
Stock,
The
yes.
stock. Was the stock end of that gun straight or was it curved?
I believe it was curved.
And what was that? What was the reason for that?
It's to fit up in your shoulder.
Your Honor, if I could have a second?
Absolutely.
This ad and somebody contacts you,
Mm-hmm.
how do they contact you?
Usually email.
Usually via email?
Right.
Do you recall whether or not you had had telephonic communication with Michael Keatley before you met with him in that parking lot to sell that gun, or whether it was via email?
Initially, it was by email, and then I believe once you get to the point of they want to see the gun, you exchange phone numbers. Then we text,
Okay.
and then that was up until we met.
Up until you met,
Right.
sometime after November 16th,
Correct.
2010.
Correct.
I don't have any other questions.
Cross-examination? Yes, thank you. Good morning, sir.
Morning.
So on that date, the defendant, Mr. Keatley, told you that he was buying the gun for target practice, didn't he?
Correct.
And he bought the gun for target practice, a gun which required the trigger to be pulled every time to fire a bullet.
Correct.
And he indicated to you that it was for him to use in target practice.
That was the impression I got. I don't remember if he specifically said that, but
can't find the right photograph, so I will
Okay.
just need more time. But you indicated that it was a white pickup truck that Mr. Keatley drove up in to meet you, is that right?
I believe so, yes. It's been a long time.
And there wasn't anybody else with him?
No, I didn't notice see anyone else.
And did you see him drive off in that same pickup truck?
Yes.
And get in the get in the driver's side,
Mm-hmm.
is that correct?
Correct.
Mm-hmm, kind of when you type it up is
Okay.
ambiguous.
Okay. Correct.
That's why I prompted you. And the right hand that you saw, Mr. Keatley's right hand wasn't deformed, but he just had a hard time holding it like normal.
Correct.
Thank you, nothing further.
Redirect?
Did you sit and focus on what a disability he appeared to have?
Focus? No, but I noticed that it reminded me of someone who had had a stroke.
In what way?
Well, one side of the body didn't work quite right. The leg on the one side didn't work right. The arm didn't work right. I don't know about the hand because he didn't raise his hand to shake my hand. So I'm assuming the hand went well.
That 22 Ruger rifle, is that something that is light enough for somebody to be able to handle one-handed?
Yes.
I don't have any other questions.
May this witness be excused by the defense?
Yes, Your Honor.
And by the state?
Yes, sir.
Thank you, sir. You may step down. You may be excused as a witness at this time. Let me have the attorneys approach briefly. after a brief discussion with the attorneys, and based on some witness scheduling issues, we're going to break for the day. So, you know, I told you to be ready to go late, and it ends up you're going home at 12:15. It happens. I don't want you to be concerned about that at all. I also don't want you to be concerned about us finishing this case this week. So we are on track, but also we are not going to start tomorrow until 12:30. So I'd like for you to go ahead and get your lunch, but then at 12:30 when we pick up, we'll go through, and again, I want you to be prepared if necessary to go past 5 o'clock. I promise you I won't hold you ever here before later than 6 o'clock, but just be prepared just in case. But this is because of some scheduling issues, and that's where we're at. So I'm going to instruct you not to discuss the case amongst yourselves or with anyone else, also not to do any research relating to the case, and to please avoid all reports of the case outside of the courtroom, and we will see you back here tomorrow at 12:30. All rise for the jury. Jury has exited. Everyone may be seated. So we still expect, though, we start at 12:30, and you've got that one witness who is ill today, and then that'll take us up to 3:30, which is the emergency room doctor somewhere. We'll take a break before the emergency room doctor. Do you expect to rest after that, or do you
Yes.
have? Okay, so no other, only those two witnesses?
That's it.
Okay. All right, and then the state said you may, or do you know?